Our current amendment is the right to clean and healthy waters. We have to start with a certain understanding of the status, the conditions of our waters here in Florida. Some of you already know these facts, but we have some new people on the call and maybe you're not familiar with them. All the information I'm going to provide you on the next two slides come from very respectable sources. The first three here come from the Florida Springs Council. We have about 1,000 springs in Florida. 80% of them are impaired. That means they're either polluted or they are suffering flow problems. By one of their studies, their analysis, it could take as much as 217 years to make some of those springs meet water quality standards under currently proposed projects. Flows in Florida springs and spring-fed rivers have declined by more than 1/3. The next fact comes from Clusa Waterkeeper. That's John Cassani down here in Southwest Florida. In my opinion, and many other Southwest Floridians, this man's opinion is gold when it comes to issues of water quality down here. Lee County, Collier County, Charlotte, etc. We have nearly 1 million acres of estuaries and 9,000 miles of streams and rivers that are contaminated with fecal bacteria. Where I live, there's a sterile river. One of the people I work with in the Reset Center, a couple of years back, she was running a camp in which they had kids in canoes and kayaks go down the sterile river. She would not permit it. Fecal bacterial levels were just too darn high. The next piece of information everybody is familiar with. This is a little bit outdated. I should have updated it. Last year, we had 1,101 manatees die. The vast majority of them, the result of starvation because our polluted water killed the seagrass that they primarily feed upon. The next four facts come from a book that I recommend everybody read, certainly everybody in South Florida. It's called A Toxic Inconvenience by Nicholas Penniman. The man has stellar credentials. This is where I learned that from 1878 to 1994, there were 64 months of red tide. That's okay, it's a natural phenomena. But in the past 27 years, there have been over 195 months of red tide in Florida. It has exploded. A recent study published down here in my local paper made a definite connection between nutrient runoff and red tides. 50,000 tons of legacy phosphorus at the bottom of Lake O. During the past 50 years, our state has issued 23,000 national pollutant discharge elimination permits to industry and agriculture to pollute the surface waters of our state. 23,000. That's 10% of the nation's total in our one state. Also from his book, as of 2018, of the 4,393 water bodies that were reviewed and assessed in the state, by the state, over half have been declared impaired. I was a public school teacher for decades. I would give tests. Everyone was in school, you took a test. If you got anywhere near 50% of the answers wrong, that constituted failure. Our environmental regulatory system is failing us. Why is that? Well, very quickly, two big reasons. I don't think I have to convince anybody that special interests have undue influence down here in Florida. We read it all the time, but I would like to substantiate that a little bit with what was, to me, an astounding study that was published back in 2014 by researchers at Princeton and Northwestern universities. They looked at laws passed between 1981 and 2002 and voter preferences on each policy decision. As researchers found, the policies overwhelmingly did not reflect the will of the people, but rather the preference of special interest groups. Policies, note the study, tend to tilt towards the wishes of the corporations and business and professional associations, and especially diverge from the will of the people. I have been asked, and maybe you have been asked, maybe you've asked it too. Don't we already have laws on file now that allow us to sue polluters, take them to court? Yes, we do. And they get used. But obviously, those laws aren't sufficient, or else we would not be suffering the conditions that we are suffering. What we need, and what our current amendment offers, is protection from permitted harm to Florida waters. Well, let's go back to that Orange County case. It was an issue in which the state was going to permit a developer to harm wetlands, to destroy them, at least a whole bunch of them. And there was little to be done except for that Orange County law. This was a test case. We need protection from special interests that have the undue influence in Tallahassee and have therefore influence over environmental policies and the DEP, and when or when not they're going to issue a permit. We need protection from changing political ideologies and circumstances. Some people think that Governor DeSantis is more of an environmentalist than Rick Scott. Well, I wouldn't dispute that, but it certainly shows how protections of waters and ecosystems can change from one administration to another. And whether or not you think DeSantis is doing a good job environmentally, we do not know what would come after him. Maybe it would be better, maybe it would be worse, but our access to clean waters should not be dependent on who happens to be in office. We need higher standards of care for Florida waters. So that's one of the major reasons, but there is another reason why our waters are the way they are, why the condition of the planet really is in the condition that it is in. And that has to do with cultural and legal paradigms that govern our relationship to the natural world. To put it simply, we see ourselves as being separate from and superior to the natural world. It's a bank of resources for our use. It fuels our economy. And a very Floridian example here, folks came down, saw the Everglades, and they said, oh, look at all this undeveloped land not being put to any good use. Let's do something useful with it. Let's develop it. No one said, oh, the Everglades have been developing for eons to perfectly suit the fauna and the flora that live there. We don't look at it like that. It's all about us. And this is where rights of nature comes in. Rights of nature movement is attempting to do two things. It is attempting to change our cultural attitude regarding the natural world, and it also wants to change the legal paradigm as well. The law sees the world in two realms: persons, and persons can bear rights, and property cannot bear rights. Corporations, I'm sure as everybody know, are legally considered persons, and they've got lots and lots of rights. Nature is property. It has no rights. A dolphin has no more rights than a toaster. And so it is because of this. Well, let me just go to the next one here. In general, the rights of nature paradigm aims for a fundamental shift in governance, providing nature with personhood and the guardians to defend its rights in court helps change the framework to a form of ecological governance rather than laws that provide only for human needs. Instead of everything being about us, it's now about the entire community of the world, and we are part of the natural community, and we change our relationship to the natural world through rights of nature. That's the bottom line. And it is because of this that back in 2019, Chuck O'Neill learned about rights of nature, and he had Thomas Lindsay come and present to a bunch of folks in his living room. And then shortly afterwards, Florida Rights of Nature Network was formed. And its greatest achievement, and kudos to Chuck and John and perhaps some other people who were intimately involved in the Orange County effort, they managed to get the Orange County Right to Clean Water Rights and Nature Amendment on the ballot, and it was approved by 89% of voters. When's the last time 9 out of 10 Americans agreed on anything? They agreed about it here, no matter what their political background, educational status, economic status. Everybody understands the paramount of clean water here in Florida. What did this law do? It granted all waterways the right to exist, to flow, be free of pollution, and to maintain a healthy ecosystem. Rights that ecosystems need, not the right to vote, not the right to bear arms, just these rights that they need. This Orange County ended up being the largest jurisdiction in the nation to pass a rights of nature law. It also granted all citizens a right to clean water. Most Americans think they have this right. We do not. Tucked away somewhere in Florida law, there is a right to clean water, but it is not a fundamental right to clean water, and we'll discuss why that is so important. And it also granted citizens the standing to bring an action in their own name or in the name of the waters, because all of the waters in Orange County were given these rights. They can't speak for themselves. People could speak for themselves. So what was the result of this? One citizen, once again, Chuck O'Neill, and for the first time ever in the nation's history, a number of bodies of water sued a developer and the Florida DEP to stop the destruction of the wetlands in Orange County. We spoke about why, the destruction of those wetlands. What did the plaintiffs want? They wanted the judge to come out and say, yes, indeed, citizens and waters in the county have these rights. They also wanted the judge to say, order an injunction. Developer, do not proceed, cause absolutely no harm until we settle this in court. Florida DEP, do not issue a permit until this is settled. In fact, that was one of the things that the plaintiffs wanted. The DEP had to administer, had to adhere to the Orange County law when considering a wetland permit. So the developer filed for a dismissal of the case. On what grounds? Well, before the Orange County voters even had a chance to vote on that, the state legislature stepped in and they preempted the right of local governments, they preempted the authority of local governments to pass laws giving any rights to nature, but also any rights regarding nature to citizens. This was one little paragraph. It was tucked away kind of sneakily in the Clean Waterways Act, which was about 110 pages long. The person who sponsored this, by the way, happens to be a legislator, but also a developer. A local government may not recognize or grant any legal rights to a plant, an animal, a body of water, or any other part of the natural environment, or grant such a person or political subdivision any specific rights relating to the natural environment not otherwise granted in the state constitution. And it was because of that preemption that after the judge heard all of the evidence from both sides, he decided that the lawsuit needed to be dismissed because the state legislature does have the authority to preempt local governments from passing such laws. This was not a super surprise. We wanted the case. We needed a test case. We argued that the preemption was unconstitutional for various reasons. The judge did not see it that way. But this is why last year, we knew that we had to do something that was going to go over the head of the legislature. And we came up with the Right to Clean Water state constitutional amendment. It would have done very much what the Orange County law did. It was modeled on that. Grant rights to clean water to the citizen, grant waterways rights, grant citizens the standing to take polluters to court. We gave ourselves 6 months to do that during a pandemic. We failed. We did not come close. Maybe, though, there's a blessing in disguise, because this year we come back and we have what we believe is, in some ways, certainly a superior law. And this is where I want to take a dive into our current amendments. For those of you who are new to the call, I want you to know that it took months and months to write this, to craft this language. I didn't do it. Kudos to Mel Martin, who was the primary author of this, but she also had lots of help, and she gives those people credit as well. It was exhaustively researched and vetted by legal experts. The Frond board was not going to go ahead with another amendment unless we knew that it was going to survive Supreme Court review. This is the ballot summary. This amendment creates a fundamental right to clean and healthy waters. The amendment may be used to sue state executive agencies for harm or threatened harm to Florida's waters, which include aquatic ecosystems. That's it. In 2 sentences, that gets to the essence of this law. You will notice that it is a right to nature. It is not a right of nature. Nothing in this law grants nature's rights. It is vastly different than the Orange County law in this respect, and the one that we advocated last year. There's a reason for this, actually 2 reasons. Number 1, the Supreme Court is going to judge our amendment according to a single subject rule, which says if you're going to amend the Constitution, it has to be very narrowly focused on one single thing. And likely they would have said, oh, right to clean water, rights of nature, that violates the single subject rule, and they would have bounced it. But on top of that, human rights have a much more advanced legal platform under our system of law than do nature rights at this point. And so that was another reason to go ahead with a right to clean water as opposed to a right of nature. So the first major section is this. Talks about the purpose. Why are we doing this? Water sustain all forms of life. Clean and healthy waters protect and promote substantial interests, including human health, safety and welfare, native fish and wildlife, conservation of natural resources, outdoor recreation, aesthetic values, business opportunities, property values, and economic interests. I'm going to bounce down a little bit more. Consequently, to promote the interests of Florida's people, businesses, organizations, communities, and economies in clean and healthy waters. The purpose here is to highlight the vital importance that clean water plays in our lives. Our health depends upon it. In case you don't know, blue-green algae blooms, cyanobacteria have been linked to neurodegenerative diseases. Obviously, people get sick from red tide, respiratory elements. Fecal bacteria causes intestinal distresses and such. And our economy very much is based on it. Down here in Southwest Florida in 2018, our tourist economy took a hit of $184 million. And that was just the beginning. Notice though, it is all very focused on us. This is a homocentric law, not an ecocentric law. But it does establish why this right, or if why we merit a fundamental right to clean water. It's critical to our well-being. And who's going to argue for clean water? That's another reason we went with this. So, although considerable attention has been given to protect and conserve waters in the state, including Article 2, Section 7 of this Constitution, and a comprehensive body of state environmental laws and regulations, such attention has not corrected the continuing decline in the conditions of the waters in the state. We already established that at the outset. But what is Article 2, Section 7? This is it. Natural resources and scenic beauty. This is what's already in our Constitution. It shall be the policy of the state to conserve and protect its natural resources and scenic beauty. Adequate provision shall be made by law for the abatement of air and water pollution and of excessive and unnecessary noise and for the conservation and protection of natural resources. Well, if this is good enough to protect our waters, then why are they in such bad condition? Part of it has to do with adequate provision. What is adequate provision? What's excessive? This is something that is a stumbling block, something that those folks up in New York State are going to learn with their new amendment. I'll get to that momentarily, but let's keep on going here. The poor condition of many important waters throughout the state has led the people of Florida in their inherent political power to create this fundamental right to clean and healthy waters. State executive agencies are instrumental to the effort to protect Florida waters from harm and threatened harm. Consequently, to promote the interests of Florida's people, businesses, organizations, communities, and economies in clean and healthy waters, this section provides for equitable remedies against the actions or inactions of state executive agencies that harm or threaten harm to Florida waters, with the goal of clean and healthy waters and the aspiration that waters in the state will one day flourish. This highlights the role that agencies play in protecting our waters. It is also about remedies, about restoring our waters. It's not about money. Nobody is going to take the state to court and ask for money. It's about cleaning up our waters, restoring our ecosystems. The next section, Declaration of Rights. The people have the inherent political power pursuant to Article 1, Section 1 of this Constitution to create the fundamental right to clean and healthy waters. And the people hereby declare this fundamental right, which is indefeasible. Indefeasible, by the way, means it cannot be altered, it cannot be overwritten, it cannot be compromised. This is a concern, because all of us have seen state citizens initiatives that the people approved, sometimes overwhelmingly, only to have the legislature compromise them afterwards. Section 1, all political power is inherent in the people. This is our document. We get to amend it when we think we need to, and we need to do it now to protect it from political ideologies and special interests. By the way, the state legislature has been doing a good job of making it more and more difficult for citizens' initiatives to be successful. What does it prohibit? It shall be unlawful and considered a violation of the right to clean and healthy waters for a state executive agency as defined herein to harm or threaten to harm Florida waters by action or inaction. Let's go back to Chuck's case. Had our amendment been in place, then when Chuck took the lawyer, took the developer and the DEP to court, he could have used this and said, I've got a fundamental right to clean and healthy waters, and it will protect these wetlands from the harm that you are threatening it with if you give this permit. This is an example of how we need a law to protect us from permitted harms. The Orange County law wasn't big enough not to get undone by the state legislature. This constitutional fundamental right is above the heads of the legislature and beyond their reach. I want to give you another concrete example. Piney Point in Tampa, environmental catastrophe. Had this law been on that books, perhaps that would not have happened, because it was the DEP's decision to take what had been an environmental situation that had nothing was going on in that gypso stack for a long time. DEP said, okay, let's try to do something to make some more money. The Army Corps of Engineers, years before that, had issued a 72-page report that said, don't do anything along those lines. They predicted almost exactly what happened would happen. With this law, a citizen could have taken the DEP to court and could have prevented their decision to open up Piney Point once again. So let's move on. Enforcement. A person, as defined herein, may bring a civil action for injunctive or declaratory relief in a court of competent jurisdiction against a state executive agency for violating this section. Because I'm a former New Yorker and I'm very happy that they passed their Green Amendment back in November, I am also conscious of its limitations. They did not say who can bring a lawsuit against the state, and that's going to be an issue. We have already thought about that. We say who can. Exhaustion of administrative remedies and notification time periods shall not be required. A plaintiff is not required to allege special or direct injury to state a claim. Who exactly is a person? Let's be clear. In the eyes of the law, it means any individual, partnership, a joint venture, corporation, any group of the foregoing to include nonprofit organizations, any tribal entity, or any government entity. We leave nothing to doubt here. Any violation under this section will be considered de novo. I'll admit I did not know what de novo meant before I read it in this amendment in earlier drafts. What does that mean? De novo means from the new. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court to hear the case. It's starting from scratch. Nor does it have to defer to what a state agency says is right and proper. It brings in its own experts. It can go and find its own scientific experts to say what is and what isn't and what should be. This is a way of highlighting and enhancing the use of sound science instead of special interests and ideologies. A state executive branch agency shall be required to demonstrate that its action or inaction as described in subsection C was necessary to promote a compelling government interest. What is a compelling government interest? A compelling government interest, a government interest is compelling if it is essential or necessary rather than a matter of choice, preference, or discretion. When government action infringes an individual's fundamental rights, the government must show that the government's action is necessary to achieve a compelling government interest. What was the compelling government interest in Chuck's case? The protection of the rights of the developer to develop and get a profit? Would that really meet the definition of a compelling government interest? How about in Key West when they passed a law that was going to prevent the selling of certain sunscreens? The state came in and preempted that. What was the compelling government interest there? Let's read on. A compelling government interest and was narrowly tailored to advance that interest. Where a party's action or inaction is found to be a substantial factor in a violation of this section, that party shall be liable for the violation and shall not avoid liability on the basis that the action or inaction of another party or non-party has also contributed to the violation. To pass strict scrutiny, the government must have passed a law to further a compelling governmental interest and must have narrowly tailored the law to achieve that interest. If there's a compelling interest, you must go about it in as narrow a way as possible. Strict scrutiny is the highest standard of review which a court will use to evaluate the constitutionality of governmental action. And a fundamental right necessitates strict scrutiny automatically. Anytime a person in Florida brings a court, files a lawsuit with our amendment, the court is immediately going to apply strict scrutiny to make sure our fundamental right doesn't get violated. A prevailing plaintiff shall be entitled to appropriate declaratory relief and to such equitable relief as may be appropriate to remedy the violation, including without limitation injunctive relief to restore waters to the condition that existed prior to the proven violation. In addition, a prevailing plaintiff shall be entitled to reasonable attorneys and expert witness fees. In case you don't know, declaratory relief, this is one of the things that Chuck was seeking, refers to a court's judgment stating the rights of parties without ordering any specific action or listing awards for damages. One of the things Chuck wanted was just for the judge to say, yes, Chuck has this right to clean water. Yes, these bodies of water have these rights to exist, to flow, and be free of pollution. When a party is requesting a declaratory judgment, the party is seeking an official declaration regarding the status of the controversy in issue. Chuck also wanted injunctive relief. It's a remedy which restrains a party from doing certain acts or requires a party to act in a certain way. It is generally only available when there is no other remedy at law and irreparable harm will result if the relief is not granted. Chuck wanted the judge to offer injunctive relief. Do not allow any development to begin because that would cause irreparable harm. Once again, this is not about money. It's about protecting our waters and restoration of our waters. Going back to New York state law, all it said was citizens have the right to clean air, clean water, and a healthy environment. It defined nothing, none of those terms. Our current amendment does. For purposes of this section, the following words and terms shall have the stated meanings. Clean and healthy waters are waters free from harm or threat of harm that occurs after the effective date of this section. Indicators of clean and healthy waters include water quality safe for native fish and wildlife. And I'm going to jump down to the rest of the green text. Sufficient habitats, water filtration, and element cycling to support thriving populations in diverse communities of native fish and wildlife. Natural flow regimes to include recharging ground or underground water and other ecological processes and functions to be intact. I want you to remember what the language was in the purpose section of the amendments. That was all about us. This is very much about ecosystems. We are not giving rights to any aspects of nature here, but the definitions, what we are seeking here, are very ecocentric. This may not be as good a law as a rights of nature law in changing people's cultural attitudes about our relationship to nature, but in this regard, in offering protections, it comes very close. The same sort of language is also in this next paragraph about harm. Again, it's very ecocentric. I won't take the time to read it now. It's online. You can read it yourselves then. To note, our amendment focuses strictly on the executive branch of the government. We need a definition here. State executive agencies shall mean the following governmental entities and offices: the governor, the cabinet, the state executive officer, and state executive departments. And it goes on to list the Fish and Wildlife Conservation Commission, water management districts, etc. Pollution, this is the point, pollution does not occur unless the executive branch, through action or inaction, allows it to occur. If we had expanded this law to allow us to go after polluters, to allow us to go after local governments, the Supreme Court probably would have bounced this because of violating single subject law. However, we maintain the law is profoundly effective because once again, the buck stops with the state executive branch. And if we can hold them accountable, then it's almost as good as going after all those other entities I just noted. What does waters mean? New York State didn't define it. Here we list all of them. Some of the folks on this call helped compose this list of all the waters, because if we had left one out, they would have been vulnerable to to harm. And now we're getting to the very end. Other constitutional provisions. This section affects constitutional provisions of the executive branch, blah, blah, blah. I'm not going to go into that. Self-executing. Implementing legislation is not required to enforce this section. This section is remedial and shall be given a liberal construction to fully effectuate its purpose. Why is this important? Because the moment that the Floridians approve this law, it is law. It goes into effect. We do not need the state legislature to implement any aspect of it, unlike some of those previous citizens' initiatives that needed legislative action. This is another reason why it's out of the reach of the legislature to compromise. The last thing I'm going to note, the effective date, like I just said, as soon as the people vote on it, it becomes law. Okay.